This is what is a matter of recovery.
Yes,
It is not a
that is
matter
what
of
this is a
recovery.
basically calculation.
Yes.
We are ready to leave it to man, but the principle remains the same manner. So far as even for
So
example,
how do you want to get the NOC?
As per their own calculation, if your lordship say the latest this supply
Yes.
chart, their dues is 3.85 at the time of suit, against which there is recovery of 1.01 from builder's property,
that was for
I'm
other
not-
account, but though we also given a credit to this account.
Yes,
since they
because
were a builder.
it was mortgage and there was
Not-
extra
not for
property.
this account.
Yes, but that is a credited,
Yes.
and then principal amount is 2.83 million. Now this has to be divided by 140 million. Principal amount, then whatever interest.
No, those who are given NOC, there is no question of.
But as per
Dividing.
our liability, I am on liability, because then suppose today nobody pays.
No, then out of that remaining persons, what, 54, except 54, those to whom you have given NOC, any amount is paid by them independently?
No, not paid, madam.
No.
They have paid the amount which was paid
To the
particular
builder.
account, which you carried it to the bank, madam. That's why the loan
Then
has
as
been
a
reduced.
society
accordingly.
is right that everyone has to pay for a property as a whole, and for
Equally.
that you to take a call.
That is what it is,
Because
madam.
they have been
Because-
given NOC, they will not pay. That is
Then
the-
you, Mr.
only
You
thing
can't
is-
have both.
no, therefore I am saying,
I
what
am
has
not-
happened is that
You are a society.
if your lordship sees my lord's last order, even your lordships have stated this was contained, it was stated that in proportionate to our share. That is what my laws have observed. Therefore, last time I have tried to put my case before your lordship that what is difficulty I am facing. It is not so that somebody has individually paid to the bank. We have also received finance from several banks. Now, there is one more interesting fact that some have taken NOC from them, SBI itself. From SBI, we have taken some of them have taken loan. They are not saying that we have charged over this property.
That is
They are
already-
granting loan to those, despite they are being charged over the
That
property.
is neither here nor there, Mr. That you go and find out OA.
Yes, no, I'm just saying, therefore, last time it
What
was
is your
stated.
prayer in the petition? 13-4.
Yes.
Why
That is
should I
13-4,
entertain all this?
what was the accusation?
Go there.
There, if
If
your
you
lordship.
are not ready to, 54% are not ready to discharge this liability as far
Yes,
as
yes.
interest aspect is concerned, this 238 has to be paid by 54 plus reasonable rate of interest, subject to whatever outcome of the suit to get you may not be dispossessed as an interim measure. Nothing beyond that. Take a call or leave it.
I take because it around 3
This is, I am not
crores by-
finally adjudicating these issues here. This is by way of to protect your protection, looking to the facts of the case as you are duped or victim of the fraud committed by the builder.
Lodge.
Both of us, not only them.
No,
No, they are
not them.
mainly, you
No,
are
yeah,
party
mainly.
to the fraud.
Therefore, I am saying, that let them not have an edge, that is
No,
what
they are
the
not
court-
having edge, but at the same time, you can not say that all 140 and therefore 140 will not pay, therefore they should allow you NOC for
out
nothing.
of this 283, if
283 plus interest. It can't be 283 simpliciter.
then it would
At least minimum 6% interest.
create disparity. That
No
is what
disparity,
I'm-
Mr. This
because-
is, there is no way. You can recover from the builder. Nobody stops you.
we have filed an FIR. If my
You can file a suit for recovery, Mr. The 12 years are not over.
if your lordship sees their own logic in the FIR.
Forget about logic. This is practical solution as on today. If you want to have it, have it. Otherwise, I am relegating you to DRT under section 7. We see your prayers.
Yes.
Only because this petition is pending since 2014, I am hearing you.
I will satisfy my lord that
I don't want to be satisfied. You satisfy learned presiding officer of the DRT for
because
further satisfaction.
because when the petition was filed, there was no provision for the third party to go to.
Now it is there, so I will
But then,
relegate you.
it will not. Then I will have to convince my lord that it will not apply retroactively when the matter is. My
All it
lords
will
may
apply to
consider-
all pending matters. I will hold that.
Milord,
So that for all times to come, banks will be happy.
banks will be
If you
happy,
want
but
to insist.
here actually I'll point out to your lordship that we are.
So argue on merits. Forget about all these things.
Yes, I may.
Yes, that would be better. આ લઈ લો પાછું તો તમને એમને નથી રસ તમારા.
Sir, I am ready to pay my lord.
No, you are not ready to
But
pay.
that amount is very high, Milord. In one
No
case,
time.
it goes to 40 lakhs, Milord. kindly see what they are saying is that I have purchased flat. Now I have given check to the builder. Now I would not know where he would deposit. He,
When you recover from builder,
he deposits in SBI
Mr.
certain
you
check.
recover it from builder.
Well, I have filed an FIR against builder. We
That
have
is,
filed.
filing FIR is not a recovery suit. By filing FIR, will
No,
you
no,
be able to
we have
recover?
shown, we are, in this case, we have invested our life saving, we were.
Therefore,
retired
in order
ONGC
to save
employee,
your life saving, you have to incur more because of the situation as on today.
That
will
is
be
what I'm
subject to
saying, if
outcome of.
situation can be redressed, then it would be better because, we will be of.
Yes,
no,
let us,
we
you
are
can
not
argue.
having,
I will try to redress as per my ability.
I am sure, my laws will do that, but so far as amount is concerned, it is
I don't
going
know
very high.
about.
I may suggest, that it has to be.
Mr. Please start arguing your merits. That would be better.
Lodge.
Instead of wasting time on this payment of amount when you are not ready to pay. Yes.
May kindly have a look at page.
Now, first of all, what is your locus to file this petition? Let us start from that.
Lodge.
How this petitioner is empowered to file this petition?
It's a society
Where
where
is the authority?
authority is
By
there.
the petitioner.
And just.
In what society has to,
No,
is any action is taken against the society by the bank?
no, they have, because this is a society of
Is
the
there this
unit
action?
holders.
See your prayers, is these prayers are against society?
No,
Any notice is issued under section 34 upon the society.
yes, if your lordship sees page 40, it is to the flats, therefore they have collectively come before your lordship.
Collectively
Page
can't
40.
come. Each is separate. This petition is not maintainable itself.
Page 40, my lord, may just have a look. at.
Maybe. It is issued to whom?
Sukan Orchid Infrastructure.
Yes. You are not Sukan Orchid Infrastructure.
Well, we are adversely affected because of this.
Society
notice.
is not adversely affected.
No, because society.
There
as
is
a-
the bylaws of the society. Are you the?
I'll produce, I have authority, but I'll produce everything, We have passed resolutions also, taken a signature of each and every members, and thereafter, this petition was filed. Where each and every member have also.
Okay, I take
cons-
it. You produce it. Now proceed on merits.
Yes, they have
Right.
consented for, filing of the petition, and there is a
Alright, I'll
resolution
take
of
it your
the
word.
society,
Alright.
Therefore, my lord, just have a look at page 40, I am still, to take instruction whether this amount, because maximum they have given me, 2.5 they can pay, 2.5 lakhs per member, this 54 members, though their dues are not, they're not a penny is due, what they have stated, they can pay 2.5. Now it would be around 1.5 crore they will get to. That is what the instructions I have got. They are ready to pay up to 2.5. And whoever doesn't pay may not get NOC, but this is the difficulty, because they have already paid full amount, plus now they are paying 2.5 just to.
No, it can't be said that they will not, those who will not pay will not get NOC. Either you pay everything or don't pay anything.
Yeah, that is what 2.5 per member they are.
2.5 will not make any difference. Mister, it is gone now. That stage is gone now. You concentrate on merits.
Lots. Page 40 is the possession notice which was
Yes.
issued. I have this resolution also, at page 41.
Yes.
Now, kindly similar submissions are of twofold. One is that if this act is to be invoked, the action has to be fair on the part of the bank. Here, what has happened is that against due, the bank has already received an amount which is 3 times more than the dues. RBI guideline says that if the loan is given for a particular project, then it has to be utilized only in that project. Recovery is to be utilized only in that project, and there is periodical, certain guidelines being issued. Divorce that guideline, they allowed builder and their family members, in their HUF account as well as individual account as well as third project account to withdraw this amount. Therefore, first is, that the action of the bank is completely unfair. I may take my law straight way to that RBI guideline, that has not been
First
answered.
of all, you point out what is action is taken by from the record.
Yes,
Then guidelines will come.
lots.
Then guidelines and action has to be compared. And then you can make a submission. as I understand, because then I will be able to understand that there is a violation of the guideline.
Page
Do you follow?
40, page 40 Milord, is the action.
Page 40.
Yes.
Yes.
Where is the undersigned being the authorized
That is
officer?
13.4 notice.
Yes, this is the action Milord, which is under challenge, and also I have prayed that they are not
But in
entitled.
view of section 17, I am not going to consider this at this stage.
Their amendment came
When the amendment came?
in 2019 or 18, I guess. That amendment came after 3 years of this petition, 3 or 4 years after the filing of present petition. And my lord, even if my lord, alternative remedy my laws are right, but in there may be case in 1 in million, my lord, where the court will interfere under
I will
226.
interfere. provided you
I will satisfy my laws that this is a case, my lord, which falls within that category. my lord, that therefore,
Then
just
how this case will fall in that rarest of rare
yes, rarest, yes.
in
And-
your language.
That's why, my lord, I am not very now in touch. This is our old matter, but I will try, my lord, that I'll leave it to your lordship.
No, I don't leave it to the court.
Lord,
Never. Never
I'll
commit that
say
mistake.
rarest of rare, this falls in this way, my lord, that they themselves violate, my lord, guidelines. They
But show
themselves,
me that which guideline
Yes,
is violated
yes,
and how it is violated.
yes, man. RBI guideline, my lord. I have annexed, my lord, RBI
Where is the
guideline.
sanction letter, Mr.?
Sanction letter recently produced, my lord. And page 340.
Yes. What did you sanction? And to whom have you sanctioned?
There are, it was sanctioned in 5/5/2011, my lord. 13 crore. FBWC, my lord, working capital finance for builder.
Who appears for this? builder?
Nobody, my lord, they are absconding us. That's a problem,
No
my
one
lord.
appears here.
None appears here, not even in before DRT also, nobody appears.
Why RBI is joined here?
By the court, my lord, court, because earlier bench felt that
Yes.
this,
all.
therefore, and my lord, builder has, I think, one of
So
the,
13 crores is the
Initially, it was sanctioned, then it was reduced to 6 crore, then one property was released out.
reduced to 6 crores.
6 crore.
Where is that revised?
That revised sanction and release deed is there, my lord. Revised sanction is at page 350, my lord.
350.
On 24/9/2011. It is another sanction.
So this is now will go on
Yes, my lord.
6 crores, right? And what is
They
the
replaced the
security? What is the security mentioned there?
Yes, ma'am. My lord,
Hypothecation of entire current assets.
yes, my lord. And
What is current assets?
it was a building, my lord, in this particular.
Where it is defined?
No, it is not defined
Then-
in this. Ma'am. It is. But the
Read-
land
read
itself
the,
remains,
your-
and the mortgage deed which is there, my lord, on record, which says that, is in the reply I have stated, my lord,
And equitable mortgage over land. Observation
land and
person-
construction thereon.
Yes. You sell the land.
The construction thereon.
I will not permit you to take the possession.
That's
Subject
what
to
I
which
was, I was
possession you
also
sell
trying
the
to
land.
work out something. We are
Nothing will
also-
be worked out, mister. The way in which you are so adamant.
No, no, we
Bank
are not,
is so
yes, a
adamant.
calculation is given, we are open to leaving certain parts paid by them and certain we will, even if there's a, whatever, we are only having the decree. We'll try to pursue it as well, this DRT, even I was,
You can take a call. He is ready to pay 250.
2.5 will be little lot, at least,
Therefore nothing can be
that
done.
we can just work it out, that's what I'm suggesting.
No,
Madam.
that is why this matter is being adjourned since last.
Sir, I have,
You are not working out.
Yes.
That is the
No, and
issue.
we have made given a calculation,
and
even it was given
I
in
have conveyed
2015.
them that they should buy peace, and I have, it is my, my lord, because they feel, my lord, they are
You
old
are
aged.
working out since January.
Well, this reply, this
before this
calculation
court
was
will not-
given in 2015 to
I will
them.
tell your lordship, before this
Page
court
311.
undertaking was made, that they will release us,
I'm
sorry,
hearing my,
But
because this is
My-
the rarest of rare case. Therefore,
my,
I will
my
not-
apologies.
And the
Yes.
affidavit in which the calculation was given is of
Mr. He is
2015.
ready to pay 2.5 lakhs.
I
If you
understand
ready
that.
and protect, subject to all of your rights of recovery.
2.5
But
will be,
possession, by taking possession, you are not going to get anything.
I understand, my lord, but 2.5 is not even a principal. We cannot even give a consent.
That
on
is not a principal, full and final settlement.
But
It
that's
is
what, my lord,
only
we
with a
can.
view to not to disturb that
that's what I was
possession as a
suggesting, Madam.
security for not, don't give NOC also.
then it's.
But you don't dispossess them by taking
If they are
2.5.
not ready to get NOC, then it will be for their problem. And I don't know if they have to
They
take a
will
call
fight out
accordingly.
because this is NOC cannot be given. Then
And
you will be
that's what
without
matters.
any security.
That can be
Yes,
worked out.
there is other securities, my lord. May I-
Therefore, you fight out before.
But, my lord,
I am not here going to conduct trial.
Yes, yes, my lord. I will.
This is under section 17. You have to go to the DRT. DRT will hear you. DRT will hear your witnesses. Everything will be stretched out by DRT, which is an expert body on the subject.
I will not take more than 15 minutes, my lord, to put before your lordships that so far as their case is concerned, my lord, against us, there will be no recovery, my lord, because of two reasons, my lord, that there are other builders' personal guarantees are
So
also
therefore,
there.
I am saying, what is
They
the?
may recover from there, my lord. My prayer before my laws is
But
to,
that cannot be done, Mister. In these proceedings, are you aware?
my lord,
That cannot be done in the the challenge to your 13-4 notice. I cannot say that 13-4 notice is without jurisdiction. Then point out that if the 13-4 is issued or it is invoked is without jurisdiction. Any action taken for recovery is without jurisdiction. Point out.
yes, that too, I was
That won't be
trying.
possible. Try your best.
Because, my lord, in one case of the same builder, the court has washed, my lord,
And remanded to DRT.
Demanded to DRT.
demanded because there was only agreement to sale.
No,
There
there
was
was a sale deal.
No, there was no.
Whatever
sale.
it may, I
can
am
read
not
out
going
from
to
the
go
order.
into it.
I'll
You
just-
concentrate on this.
Yes, therefore I'll.
Has any court quashed the notice for all intents and purpose?
Yes, my lord, that judgment may I last time I have, my lord, produced before your Shukla sir. That there, my lord, these aspects have been considered, my lord, only because there were agreement to sell, they say you establish your right.
Whatever
my
it
case,
may
there
be,
is
this
sale
will
deed.
not, what
No,
will
there
never
was also sale
cost
deed
the
also.
society.
My lord, page 60, page 53, my lord, may just have a look at of this judgment.
Yes, lead. Whatever you want.
Page para 30, my lord. page.
Yes.
It is in this background, the submission made by learned advocate Sri Rao with much emphasis on the provisions of SARFAESI Act requires to be considered. Therefore, though the statutory provisions are made empowering the financial institutions like the bank to have a recourse under the statutory provision for
Have you
recovery
accepted
of-
this order?
I'm sorry.
Have you accepted or challenged?
No,
we
I
have
we
not
are not.
challenged.
That is fine.
That is fine. I don't know, but we are not, Mr. Rao was appearing in this matter. I'm not sure whether it is challenged or not.
Kind of.
But it was a sale deed was also there.
I'll
Yes.
find out.
Read
No, I'm-
complete.
Yes. That they say it is required to statutory powers with the authority like the respond back could be permitted to be abused. The existence of power or
The
recourse.
exercise of power.
Yes, the exercise, I'm sorry, the exercise of powers or the recourse under the statutory provision is one thing, and having allowed the irregularities and or having remained indifferent for the loan or the advance suggesting one kind of favor to the respond number two would not entitle respond number one bank to resort to SARFAESI acquired third party without issuance of notice. It is in this context, it is well settled, whenever the text of the
But
statute.
they have not issued, have you issued notice or not? Then? Upon the flat
No,
owners?
no,
Then why do you bother? Let them
because
issue
they are,
notice.
they have issued possession notice for the flats, my lord. We are owners of the flats.
But then they
This-
can't take possession without notice.
That notice will go because it is for the flat, according to me, my lord,
No,
because-
it won't
yes,
be.
Because today, suppose.
Read rule 8.3.
I may point out my, just
Rule 8.5.
if it appeals
Unless
to-
and until it is given to the possessor, person who is in possession, no possession can be
if
taken.
it appeals to. my
I'll
lord,
hold that.
If
They will issue notice and then if they will proceed
if it
further.
appeals
Then
to
we
my lord,
challenge
my
that
lord,
notice
my
before
lord,
the
what has
DRT.
happened is that some are them from outstate, my lord. They have been working here, they are 70, 80 year
Sir,
old.
I am not
They,
concerned
their
with this.
life saving is involved. Now they want to shift and sell these properties, my lord, because they just want to, their investment is there, my lord. I
Then the,
kindly,
you have to
for a
accept
retired
that
person, my lord, it will
If there
be.
is a litigation in this property, mister, and
my lord,
therefore unless and until the litigation is.
that is what
over,
I'm saying,
you
for a
cannot
retired
get
person, my lord,
clearance.
this would be, I'm trying to convince them that they will get NOC.
Mister,
for
you
two-
issue fresh notice to all.
we will-
Take them. They'll issue fresh notice and then you challenge in accordance with law. That is after amendment.
Then. But
Each individual flat owners, 140
As per
notices,
the law, we will-
as per law, you issue.
we we don't have any privity with the bank, Milord. We have not taken loan. That is what
Can you challenge it? You can get 60 days for filing objection.
I am appealing, Milord,
thereafter-
to your lordships
I
under
am not,
226. Milord.
this notice is not issued to you.
But then I'll satisfy my lord that this notice at page 40, my lord, kindly see the flats are of possession of the flat which are belonging to us are sought to be taken.
So that notice is also without, now it is over.
That is at page 40, my lord, there is, the flats numbers are also given.
What is the date of this notice?
This notice is, my lord, date is not mentioned, but
Then
12/6/40.
2014. We are in 2022. This notice is just becoming
There is a
infructuous.
stay since then, man. There is a stay since then.
I will vacate the state
If my lord,
and you take appropriate proceedings in accordance with.
if my lord may just have a look at 2 orders, my lord, passed in the present matter only, my lord, while the matter was being admitted, my lord. So, these aspects were considered by the honorable court, my lord. So, the order dated 5/10/2015, if your lordship can just have the order dated 5/10/2015. Just to appeal to my lord, if it appeals. my lord. Because their conduct is also being noted, my lord. They, in the court, my lord,
In
said.
view of that only, I am quashing this notice and permitting them to issue fresh notice. What, the petition is allowed? What else?
5/10/2000.
I'll quash this notice with permission to them to take course. in
You know,
accordance
under
with-
ordinary law, they can take, you know, that is what my
But
request.
that is why should
is
I
what-
say anything?
So,
It is
not
it is
fresh
for
notice,
you to
appropriate,
challenge this.
appropriate action they can take, my lord. But
In
if
in
my law
accordance with
says
law.
fresh notice, they
That
will
will
not.
not serve
I am
their
not saying
purpose.
anything, that they can do any action under the law, under the sky, in accordance with law.
Lodge. Whatever.
I leave
permission. Look, I will request my learned friend
I
because, my
also
lord,
genuinely
I have-
want to make the
in
things
fact,
better,
my
my
lord,
lord, but there is
even-
some difference of amount.
even
Now,
before this court, my lord, when
there's
there
observation.
was appearance, there was observation that they will relieve us, my lord. That is, and then they filed an affidavit that they will relieve us.
That is
Then
clarified also,
subsequently,
my
they
subsequent-
clarified that they are not going to relieve us. But it is a financial terrorism on us. Milord. That is what the, if your lordship sees that order, Milord, thinks.
It has been read
When
out
you
last.
purchase the property, were you
Lodge.
not aware
Exactly.
about the finance taken by the
No,
builder?
Milord, no,
It was there,
no.
it was
And
part of-
NOCs were issued
That
by
is the
them
wrong
only.
statement. Page
And-
77
And
may
Milord,
be seen.
even
my lord.
title was also given.
Page 77 and 79 may be seen. my
Yes,
lord.
Milord, I'll read.
The
that.
charge was very much registered. They have not
No,
bothered
no,
to check up, my lord.
no, not bother to check up, Milord.
My date of
Public
charge may be
notice
seen.
was given by some flat owners before
Agreed, but
purchasing.
on the contrary,
And they have themselves.
Everything will be decided by DRT provided.
Yes, yes,
they
well,
issue
I
a
am not
notice.
saying, therefore I am not raising any disputed facts, but we were not aware, neither sale deed nor agreement to
These
say.
are all disputed
but
questions.
this is prior to that, my lord. The charge registration is 6/5/2011, page 77.
Yes.
The State Bank of India, દસ્તાવેજ કરીને એના કોર્ટના હુકમના અથવા આદેશ સંબોધિત
Well,
વાંધો.
Page 127 at the same time may be seen.
And page 79 also, my lord.
Page 127, my lord, may just have a look at.
The charge was very much on the record. They
Kindly,
don't
kindly see page 127. Milord. Now, if these, they themselves have given
You
an.
take instruction to withdraw this notice if you to issue a fresh,
bother. I take instruction.
come at 2.
Please,
Then nothing will remain in this.
I take instruction.
But
So
Milord,
far as
we-
13/4 is concerned.
13.4 is concerned, that you can issue anytime
Yes, my lord. Fresh notice may be.
in accordance with law.
Please, I take instruction.
But then only one thing, Milord, I know, Milord, nothing will remain, but ultimately, Milord, they will suffer, Milord, they will be victim. Kindly
They
see,
will suffer for
only-
all times to come.
127, therefore I am before your lordship, Milord, to, with folded hands, your lordship may kindly see, Milord, 127, only for a
Yes, I
moment.
want-
Yes, Milord, they are saying that their charge is registered. In this, Milord, we have advised that bank has no objection releasing the charge over the above flat to Axis Bank, subject to receipt of rupees so and so, so and so.
That amount.
Now,
is-
what they are saying is that as per this, they have received amount, more than what is loan amount. But subsequent to it, Milord,
Mr. Popat,
lordship,
now they will have to apply their mind whether any amount is to be recovered or not. They have to specify. It is not as if that they will also will issue a mechanical notice. And if that is so, then you are benefited. Why do you bother?
and Milord, at page 232, I have produced revenue record. If
Why should I go into all these
No, no,
disputed
two-
questions of-
228, it starts, Milord, there is no charge appearing in revenue record.
77 has been produced by them only.
No, just to show to your lordship. This is how, my lord, this has gone, my lord, and there is also guideline, my lord, which is at page 284, my lord, which says that it is only for specific project they can release. Now, after you receive money, you allow builder to withdraw. You don't take any departmental action.
No, we
Your
have
officers
taken-
are at error, my lord, which even the courts have found.
You have a very good case if the notice is issued. You
Lord.
take withdraw this.
We will take instruction.
This notice is not sustainable. sir.
I
If you don't withdraw, I will caution.
with liberty to issue 13 fresh 13 4
So
as
that-
per the law.
With liberty to take all actions under the law,
Please, I'll take instruction.
whichever is permissible.
The moment, my lord, my learned gets that liberty, my lord, they will.
Liberty has to be there.
Yes, liberty
I
to
can't
take
restrict
action,
the
my lord,
liberty.
not to issue. That is what I am requesting. I will,
Action
I'll urge on
includes-
at 2:30, my lord, appropriate action. my lord. Then under ordinary law, my lord, they already have it.
All actions under the law, whichever is applicable
Lodge.
according to the bank. How do I restrict them that or say that which action is to be taken
Lodge,
or which action should not be taken?
lodge, oblige,
That has to be tested by the authority, whether the action is taken rightly or wrongly against you. At present, there is no action against you.
lodge,
Please.
oblige.
Cell number 5, Tanna Associates. I am on behalf of Mr. Tanna. He has argued this matter. I believe Mr. Antani was supposed to show judgment. Please, ma'am. Six is subject. Serial number 7. AS Vakil Amar Bhatt Diwan.
Yes, what is your reason? Monday. Monday is available. You can send it. Monday will say he has gone to.
The matter has post issuance of notice to Mr. Vyas. This is the fourth time he is requesting for time.
Can be kept on second.